On this episode of Law Weekly, more reactions as legal practitioners in Lagos take to the streets in protest against police brutality on lawyers and other Nigerians. This protest is coming especially on the heels of the recent unlawful detention of a Lagos-based lawyer, Olumide Sonupe, by the police at Gowon Estate Police Station for 2 days. Also on the program, we'll be joined by two legal practitioners who will share with us their views on the task ahead of the judiciary this new year. Plus, the Supreme Court finally lays to rest the legal battle in 8 states of the country. We have a recap of that and other legal stories. Hello and welcome to the program. I'm Shola Shuyeli. We begin with the lawyers' protest. Hundreds of lawyers from the 5 Lagos branches of the Nigerian Bar Association (NBA) embarked on a peaceful protest against police brutality and harassment. The lawyers were led by the chairman of the NBA Security Agencies Relations Committee, Senior Advocate of Nigeria, Chukwuka Ikwazom, the chairman of the Lagos branch, Bisi Makojola, the chairman of the Ikeja branch, Seyi Olawumi, and the chairman of the other branches in the state. Other bar leaders, including Senior Advocate of Nigeria, Femi Falana, also joined in the protest. We have the report of the protest and reactions trailing it.
Following the recent unlawful detention of a legal practitioner Olumide Sonupe by the Divisional Police Officer, DPO Gowon Estate Division, Lagos, and other recent incidents of police brutality against lawyers and citizens, hundreds of Nigerian lawyers gathered in Lagos on Thursday, January 11th, at the Bar Center of the Ikeja branch of the Nigerian Bar Association. The lawyers are drawn from all the 5 branches of the association in Lagos, and after a gathering, the plan is to take to the streets in protest against police brutality. They also plan to submit a petition to the Commissioner of Police in Lagos. But the commissioner, who apparently got wind of the planned protest, shows up at the gathering. The lawyers resisted his presence and is moved to address them at the Bar Center.
Can we all sit down, please? Can we all sit down, please? Can we all sit down? Can we all sit down?
Following the intervention of Senior Advocate of Nigeria, Femi Falana, the commissioner is allowed to join the gathering.
Please let us as very disciplined people, and this is the most noble profession in the world, let us behave like noble people. After we have had interaction with the senior police officer, led by the Commissioner of Police, we can then on our own decide on the way forward. That is my suggestion.
Honorable Commissioner, as lawyers, we are very concerned about the various attempts that we have seen on the parts of security agencies in Nigeria to impede the work that we do as lawyers. I always say this, and I think I've said it this morning, that nobody is suggesting that lawyers are above the law. If a lawyer breaks the law, the due process of law should take its course. But what is totally unacceptable, is that a lawyer be assaulted or intimidated in the course of providing legal services to his client. The very confidence in the rule of law will be destroyed if a lawyer is not free to discharge his professional duties to his clients. As far as the incident at Gowon Estate Police Station is concerned, we demand, sir, that a thorough investigation of that incident be carried out. Sir, we understand that the station has CCTV. That investigation must involve the review of CCTV footage, and that investigation must involve us. And secondly, sir, if after that investigation any officers are found culpable, we demand that they be disciplined. And sir, discipline is not redeployment, sir. It is not redeployment. Redeployment is not discipline. Because if you redeploy the person will still go to the new station and continue what he or she was doing.
The lawyers take turns to lay their complaints and grievances against the officers of the police force. After listening to the lawyers, the police commissioner has this to say.
The issue of what happened to the barrister, I'm coming back to it. It's quite unfortunate, and we don't like it and we will not tolerate it, and we will never tolerate it. I've also ordered that the DPO should be removed, apart from issuing him a departmental query, which goes a long way to affect, which will go a long way in affecting his career progression. That is even more serious than removing him from as the DPO. I want to suggest, especially, that we should have a forum whereby at least every month lawyers and police officers will meet to discuss gray areas and find a way of solving it. So, please, I promise sincerely and utterly that during my watch as Commissioner of Police, there will be this kind of incident will not happen again.
He also receives the protest letter.
Thank you very much. This is a major exhibit.
Thank you, sir. Thank you very much. Thank you.
We shall always fight for our land.
This did not, however, stop the planned protest, as the lawyers subsequently marched from the Bar Center past the Lagos High Court Ikeja to the headquarters of the State Police Command. The protest ended right where they began, after which they took turns to address the media on why the peaceful protest was necessary.
Lawyers in Lagos State, we have 5 branches of the Nigerian Bar Association, decided to come together today to protest against police brutality because of the recent maltreatment meted out to one of our colleagues. And we are making his case. We are making a case through him that Nigerian lawyers will no longer allow the brutalization of lawyers and indeed other citizens.
I was in a cell with about 5 other cellmates, and all their cases were all purely civil matter. And they were telling me they've been there for 3-4 days. So the injustice is not only meted to me, it was meted to a lot of other people, ranging from the carpenter, the electrician, and so many other people. So I just want to say I appreciate everyone trying to help, and I wish that justice is done in the matter.
This protest march is not about our colleague here. It's about seeking justice. If our member has behaved in an unruly manner, then let the law take its course. Lawyers are not above the law. And again, we need to press home the fact that this is about the ordinary man on the streets. And so we're not coming out because it is our colleague that is involved. We're saying that when you go into a police station, as a Nigerian, you have a right to be treated in the most civil manner that you deserve. You cannot go in there and they're subjecting you to all form of harassment. They tell you to drop your phone at the entrance. I mean, if you're not doing anything in your station, that is unholy. Why are you asking us to drop our phones?
There's this big problem, which is in relation to bail. Bail is ordinarily free, but the entire Nigerian who has ever had any interaction with the police knows that bail is never free at the police stations. And we're using today to condemn the harassment, the extortion of money from suspects under the guise of bail. Bail is free and must continue to remain free.
The lawyers also say they will be filing a fundamental rights suit against the police for the unlawful detention and harassment of their member, Mr. Olumide Shonupe.
Moving on now, the Supreme Court has been busy churning out judgments. On Friday, the court laid to rest the legal battles in 8 states At least 5 sitting state governors were in the court for the judgments. We have the recap of that and other stories from the courts up next.
We begin with the report that it was not only in Lagos that lawyers took to the streets in protest. In Kenya, dozens of legal professionals also took to the streets of Nairobi, the capital city, in a demonstration organized by the Labour Society of Kenya to protest President William Ruto's threat to defy court orders. The march, which started at the Supreme Court and headed towards the President's office, is aimed at addressing concerns raised by the President's recent statements. President Ruto faced severe criticisms last week when he publicly declared his intentions to disregard court orders, asserting that some unnamed judges had allegedly colluded with opposition figures and cartels to obstruct his administration's projects. In recent days, Ruto has also repeatedly threatened to remove judges he accuses of teaming up with his political rivals to frustrate his attempts to address unemployment in Kenya and provide affordable housing and universal health care. But many say that the head of state has not produced any evidence to back his claims that some judges are corrupt. Back in Nigeria, the Supreme Court has upheld the return of Governor Babajide Sanwo-Olu of Lagos, dismissing appeals from Gbadebo Rose-Vival of the Labour Party and Abdulaziz Adediro of the People's Democratic Party. The court held that the challenge to the eligibility of the deputy governor to stand for office cannot stand, as a person with dual citizenship can only forfeit the right to be elected governor if such a person renounces their Nigerian citizenship. In Bauchi State, Governor Bala Mohammed of the People's Democratic Party was affirmed as the governor as the court dismissed the appeal of Sadiq Abubakar of the All Progressives Congress for lacking in merit. The much-anticipated judgment for Kano State saw the Supreme Court overturning the dismissal of Abba Yusuf of the New Nigeria People's Party. Justice John Okoro emphasized the need for judges to be more meticulous when the court held that Section 71 of the Electoral Act relied upon the lower court does not apply in this case. In the fourth judgment, Justice Emmanuel Agim affirmed Governor Dauda Lawal as the governor of Zamfara State, setting aside the Court of Appeal's decision that declared the governorship election inconclusive and ordered a rerun in 3 local government areas. The court also reversed the Court of Appeal judgment in Plateau State, which voided the election of Governor Caleb Mutwang. The court held that the issue of the primaries which produced the governor was outside the jurisdiction of the lower court, Maid Court. The court similarly upheld the elections in Abia, Ebonyi, and Cross River states. Away from the Supreme Court, the Federal Capital Territory High Court, sitting in Apo, has granted bail and the sum of 50 million naira to a former Minister of Power and Steel, Olu Agunloye. Mr. Agunloye was arraigned before Justice Jude Onwebozie on a 7-count charge bordering on fraudulent award of a contract and official corruption. The judge had ordered his remand in Kuje Correctional Center pending the hearing and ruling on the bail application. 24 hours after the arraignment, the judge said, having considered the arguments for and against bail, the pendulum of the court swings in favor of granting bail to the defendant. He granted 50 million naira bail to the defendant and ordered him to produce 2 sureties in like sum. The sureties must be reputable and people of means resident within the FCT. They must also have properties worth 300 million naira with a certificate of occupancy that must be verifiable. The matter has been adjourned to February 12. Still at the Federal Capital Territory High Court, Justice Olukayode Adeniyi has awarded the sum of 100 million naira against the federal government in favor of the former governor of the central bank, Mr. Godwin Emefiele, for the violation of his rights to personal liberty. The court also declared his prolonged detention without trial as a flagrant violation to his fundamental rights. It restrained the federal government and its agents from rearresting or detaining the former CBN governor without an order of court. The judgment was given in a fundamental human rights suit filed by the former CBN governor following his prolonged detention in the custody of the Department of State Services. The prosecuting agency, the Economic and Financial Crimes Commission that the EFCC has, however, vowed to challenge the decision. And we round off with the report that the Lagos State Sexual Offences and Domestic Violence Court, sitting in Ikeja, has fixed January 26 to deliver judgment in the case of a cleric, Bishop Oluwafeyi Rokpo Daniel, accused of raping two of his church members. Justice Rahman Oshodi fixed the date for judgment after the prosecution led by Babajide Boye and the defendant's lawyer, Fola Awonusi, abducted their final written addresses. Daniel was arraigned before the court by the Lagos State government on a 2-count charge of rape contrary to Section 260, subsection 2 of the Criminal Laws of Lagos State 2015. The state had claimed that the defendant, the founder of Irene Christian Ministry, allegedly committed the offences sometime in June 2020 at Ikota Villa Estate, Lekki, Lagos. He, however, pleaded not guilty to the charge.
Last week on the show, we brought the views of 3 senior advocates on some of the challenges confronting the judiciary and what stakeholders and government can do better this year. Now we'll share with you the views of 2 legal practitioners on the issue, all of which is aimed at setting an agenda for the sector, one that should guarantee the necessary reforms needed to move the judicial sector forward.
I strongly believe that the number one challenge of the judiciary as of today appears to me to be the bar itself. That's the Nigeria Bar Association. It appears we are more of a challenge to the judiciary because, you see, it has become an habit for lawyers. It's like we're competing in condemning our own judiciary. We may, or definitely, we will have bad eggs, just like in every other society. But what we are having now is blanket condemnation. Lawyers are eager to go on air. The judiciary is corrupt. Judiciary is corrupt. It is your house. If you destroy it, nobody is going to build it for you. You can only build it by yourself. We can identify, if you know any bad egg, you have a duty to identify it, and we can deal with that. But to do collective destruction, I think it will be a serious problem. We must look inward. We must look into ourselves. So the second challenge is the parliament, particularly in the last year. The National Assembly sat down to amend the Act, the Electoral Act, and confer jurisdiction on the Federal High Court. They did not ask themselves how many judges are in Federal High Court. What are we going to do? Are we going to increase it? Do we need to increase it? You now give them that number of cases. And by so doing, you left so many cases, you curl attendance into other cases. For that reason, I almost got a petition against myself. Somebody gave me a case from US in Ibadan. And I told him we couldn't get it. He thought I was lying. And Ibadan, then they gave us 2 judges. Justice Aguma, very brilliant and very hardworking. And Justice Okeke, which I could not even access because I did not even appear before. As soon as Justice Okeke came in, they took her to Jigawa to go ahead the election petition matter. Remaining only Justice Aguma attending to all pre-election matters, nothing more. Every other thing was a standstill. So it took the other man from US to cross-check here and there for him to know that I was not lying. For the judiciary to be on a clean slate, I think all hands must be on desk, not just the judiciary alone. First and foremost, I think it is high time the parliament needs to look into the provisions dealing with appointment of judges. To be a high court judge, all you need is just 10 years post-score. It doesn't matter whether you are selling memen or akara. I think we need to really address that area, and we should stop deceiving ourselves. We should have regulations that will let us look into that beyond NJC regulations. We should have regulations, we should have acts that will enable us to look to aim at getting the best, the brilliant. You have the way of, we know
we still have a way of saying this is the way, these are the regulations. And when it comes to Court of Appeal, even if we are going to, for me, I strongly believe that, for me personally, I believe you ought to be a judge of the High Court for some years before you can go to Court of Appeal. And before you go to Supreme Court, you should be a judge of Court of Appeal. I don't believe in all these people saying struggling, pick SAN, pick this, pick that. And you have so many brilliant and good ones against them. What's this them doing to identify the good one, the brilliant one, the hardworking one? Then, how about the ladder of seniority? What are we doing about it? You see, if you allow a system, if a system is able to compromise in your favor, that system equally has the capacity to compromise against you. And that is why it is very important that we should have fairness, that the regulations should be about fairness. So that is one area that we need to move forward, and we must admit that if we want to move forward, there's a need for the Parliament to amend the number of cases going to the Supreme Court, particularly pre-election matters. We have to realize that they are neither machines nor angels. They are human beings like us. And as of today, we need to enlarge the Court of Appeal. You can't be talking about, by now we should be talking of nothing less than about 300 justices in Court of Appeal, if we are to be dealing with this kind of cases that we are dealing with. But to say just about 90 to deal with election matter, you see that for the election matter now we have suspended all other cases. We are hardly attending to them, even including the one that deal with foreign investment. So when Mr. President is saying, I'm going out, I'm running around, just a simple search about our judicial system, where people will be able to say, how does it look like? There is nobody that will hear that his case will last about 5 to 10 years in your courts, and he will be coming to come and invest in the country. I don't think anybody will come and do that.
So funding is a major challenge. Why are we saying funding? As we speak, in the Federal Capital Territory, magistrates share courtrooms. That's not the situation. Every magistrate should have his own courtroom. As we speak, magistrates share courtrooms. Magistrates, the bulk of the magistrates in FCT Abuja, which is supposed to be an elite city in Nigeria, don't have cars. Magistrates are compelled to enter public transport with their accused they try in their courts, with persons doing they do matters in their court. So that's a very challenging thing. But there's a good development in 2024 budget where you saw that the National Assembly drove away the Revenue and Mobilization Committee to go and increase the allocation to the Judiciary. So it was increased from 174 billion that was used to be the practice for several consistent amount voted for the Judiciary to about 344 billion that is assigned to the Judiciary. So with this, we might see improvement in the welfare and infrastructures in the Judiciary. Now, if we have that increment now, we know first and foremost the infrastructure, because it goes beyond the courtroom. It goes beyond the judge. What are the facilities around the judge that will make the judge work very well? Talk about welfare of judges. Because some lawyers, senior lawyers, were forced to go to the industrial court to get a judgment that judges' remuneration should be increased. So let's also talk about their welfare. So, because a happy man is a stable man that will do the needful without fear or favor. So let's also talk about their welfare. Well, with this increment, we hope that the judicial package will be increased. The infrastructure around the judiciary should be also increased. You cannot have magistrates plying the road with people that appear before them in courts, and the necessary apparatus that will make an office functional should be released to them. If that is done, that you have effective and efficient LAs working for you, that will assist in doing a lot of things. That is on the other front side. Then we now have to also look at the appointment procedures of judges to bench also. We now know since we have funds now, quality of person going to the bench should be more scrutinized, so that when we have persons there, we know these are persons that will understand the law, that we appreciate the law. And when you argue there, we'll be able to understand it. And when you kid out the welfare and infrastructure around the judiciary, that nobody will just come and unnecessarily influence you because you are comfortable where you are without any desire to exceed it. And the knowledge of the law now you'll be able to give judgment that, as you rightly say, will not be in the eyes of the storm again. But you should know something fundamental. A lot of persons outside don't understand the law. You look at it, law is not emotion, law is not sentiment, law is raw fact. And there are certain procedures that, if it's not well followed, might also make you lose a well laid out case that ordinarily the common man on the street might say, this is black and white, but if you don't follow it, so these are things that people also look at. That's why I highly commend the Chief Justice of Nigeria. I say, we will not be bullied. We will not be allowed ourselves to be intimidated, because the law is as it is. So when we put that into cognizance, that we appoint judges that appreciate the law, then whatever you do, you will not come and say this judgment is in the eyes of the storm, or this justice in the eyes of the storm. With this infrastructure, with the funds increase, I want to believe that infrastructure-wise and other enablement that will make the judge function better will be followed up. And if these are done, I think we'll have a better judiciary that we can be proud of.
And this is where we adjourn proceedings for today. Do remember to check out the Channels TV website for a replay of this episode of the program, as well as past episodes. Please also send in any feedback via our social media handles. I'm Shola Sheeli. Thank you for watching, and see you next time.